Here on behalf of the appellant, and I would like to save about 5 minutes rebuttal if necessary. All right, this case is involving children, and it's involving a third party who is not the father of the child. These are grandparents, and
Why didn't Ms. Williams just set another hearing? Why just agree with opposing counsel to continue the hearing at a later time?
well, there is nothing in either the petition that takes my client and says that because of these medical problems, assuming them to be true, nothing says that these problems are making my client
The order
unfit.
said the emergency order that was entered is denied as to the emergency nature, okay?
That's
That's
the,
not an enter. It said the testimony and evidence to be entered at the hearing was held on October 19th was not completed. The hearing
Correct.
shall be continued until a future date to be set by the parties. Why did Ms. Wiggins and her counsel not set another hearing to continue presenting evidence?
because, Your Honor, they have to prove their case. They are with the state.
How long have you practiced? Have you ever had a hearing in which at the initial date that was set, all the evidence wasn't able to be presented and had to be continued to another day? Has it ever happened in your practice?
The answer
Were you
is
counsel below?
very rarely, but
Were
it
you
does.
counsel below?
Yeah.
Were you
I
counsel
think-
at the trial court?
If I may, Your Honor.
What?
What
Were
I'm,
you counsel were you trial counsel?
yes,
Okay. Has it ever happened in your practice that a hearing concluded and the trial court said that, not all the witnesses got to be presented, haven't given ample time for the attorneys to present argument, we're going to continue this to another day? Has that ever happened to you?
oh, all the time.
So why wasn't another hearing set?
Because, Your Honor, this deals with the constitutional, the
So
unconstitutional.
wouldn't that suggest that the trial court should be able to have ample time and both parties have ample time for such a momentous decision, that ample time would be given to make a decision?
Your Honor, the thing is that they had the burden of proof. The burden of proof is clear.
The trial judge, we know from what's in front of us, because we don't have a transcript, that the trial judge said they haven't had a chance to meet their burden of proof because I ran out of time and there should be another hearing to allow me to complete my labor, which brings me to another question, which is, how do we even have jurisdiction here? The judicial labor is not complete on this temporary arrangement.
Because it's a non-final order.
Well, I understand, I mean, I read what you said, and I read the 9.130, but typically, even for a non-final order, we need the trial judge's labor as to that disposition must be concluded, because otherwise, every day we would be reviewing denials of motions to dismiss, et cetera. But here, the trial judge made plain that she hadn't concluded her labor. So I think that's where it raises a couple of issues, in my mind, primarily jurisdiction, and Mr. Judkinson has others. But
Well, I understand, Your Honor, except for one problem. If you look at the complaint, the petition, there is nothing in the petition that would support any type of emergency
So you're saying
relief.
that the judge should have ruled in favor of your client without evidence because the petition's
No.
assertions were so insufficient?
No, what they should have done is they should have brought an affidavit of a doctor that says, my client is unfit.
Couldn't they have brought that at the second hearing?
Then they should have put him on if they're going to keep the child in violation of my client's constitutional right. This is not just a simple matter of money. This is my client has an absolute constitutional right to possession of her child. They are withholding that constitutional possession. If the court...
You've argued the constitutional business very well in your briefs. Let's focus on what transpired here procedurally.
Okay.
The trial judge, they may have had this witness, the affidavit that you just described, waiting in the wings, but the trial judge said, time's up. come back another day, maybe tomorrow, but I'm not through yet, I need to hear the rest of this evidence before I can dispose of it. We're dealing with a verified petition, it sets forth the child's medical problems. There was no counter affidavit submitted, and the trial judge recited that the parties appeared with counsel and that she heard testimony of the mother, the father, I'm sorry, the grandmother, the father, and the mother. That's recited in the order, and that's all we have.
That's correct.
And so if we just confine to that, without worrying about whether there should have been more hearing, we do this as final, the way you want us to, the only record we have says the trial judge considered this much evidence. You take the position it wasn't insufficient to carry the burden, but the trial judge found that it was. So without a record to determine, without a transcript to see what the trial judge did actually hear and consider, how do we find that to be erroneous?
Because if you look at the petition, there is nothing in the petition that supports any type of interference by the state into my client's constitutional rights.
Well, what about where it says the mother currently resides in her car and is unemployed and she's incapable of providing a safe home? And there are other,
If I may, it is my understanding that the question, that statement should not have been considered in the emergency motion to begin with, because there is no basis for her to know that. It just says she's unstable. What does that mean? She lives in her car.
well, then the trial judge heard her testimony, which we don't know if she controverted that she lives in her car. Maybe she lives at the Ritz-Carlton and she told the trial judge that at the hearing. And the trial judge still found there was enough evidence in the testimony that she heard to enter a temporary order pending completion of the hearing.
But this is, to enter the temporary order, there has got to be sufficient evidence to show that these people would prevail. There is nothing in any of this stuff that shows that.
Let me say this, to touch on what Judge LeBridge mentioned about jurisdiction. The rule says that we have jurisdiction on a non-final order to review orders that determine the rights or obligation of a party regarding child custody. So in an order that says testimony and evidence was not completed and the hearing shall be continued until a future date, how are we supposed to conclude that this was an order that determined the rights and obligations of a party regarding child custody?
Because the order determined that there was, that they had at least shown somewhere that there was a clear and convincing evidence to show that she had, that she was unfit.
Where in the order does it say that?
It doesn't. It says that the child shall remain with the mother under the statute that they were.
That was the status quo, but you hadn't finished the hearing.
Well, it says.
There's a pickup order, right? There's a pickup order, and then there's an emergency, there's a petition on the ground. So the pickup order, until the determination was made that whether or not Ms. Wiggins was unfit or not, there's no determination, whether or not there was a detriment to the child to remain with the biological mother, how can we say under the Rule 9.130 there was a determination of the rights to custody?
Because my client doesn't have her child. That is a declaration by the state that is unconstitutional against my
The
client.
verified motion recites effectively the status quo was the child residing with the grandparents. So isn't this just a preservation of status quo pending a hearing that should have been concluded before it came to us?
It doesn't matter. The status quo is not the basis. That's not the best interest of the children. It's not a status quo question. It is one of whether my
And
client.
you have half the parents agreeing that the child should stay with the grandparents.
We have what?
The father consented.
Right,
to this arrangement.
right.
And-
But that doesn't-
And it was in place.
Yes, but
And so that is the status quo, and the trial judge has not, her order, one fair read of it is that she hasn't been able to make a final determination as to temporary custody of this child.
Because my client, whether or not the father has agreed, it has to be agreed by both parties under the statute. My client disagreed. At that point, the state, that my client, under the Constitution, has the right to possession and rear her child unless it is shown by clear and convincing evidence that the child, that the mother is unfit or essentially presents danger of abandoned, abused, and neglected under Chapter 39.
Let me ask you this then, so let's say at any time, so if we write an opinion reversing, my presumption that would have to say something along these lines. Anytime that the trial court has pending before it, let's see here, emergency verified motion for child pickup order, and then a countervailing petition filed on behalf of family members for custody. Anytime that those motions are pending before the trial court, and the trial court is unable to resolve them by the end of a hearing that has been set, the motion for pickup order is deemed granted, right? Or else it's error. In other words, if you don't finish the hearing,
That's not, well, first of all,
how else would the opinion read? If we said the error is, well, should the error have been, you should have taken it all night, you should have just cleared your afternoon docket and kept the hearing going until midnight. In other words, wouldn't our opinion have to say, anytime there's an emergency motion for pickup order filed by a biological mother, and the hearing that concludes without resolution, that's the end of the story. It's error not to grant the pickup order. Is that it?
no, that's not it. I'm having a hard time understanding because the facts as set forth in the record do not support anything.
But the order says that all the facts have not yet been adduced.
That's right. But before the state can interfere with the constitutional right, they have to show, and the statute specifically says that before it does, it's got to make findings and you've got to have a hearing and you've got to do all
Doesn't
that.
that suggest that my hypothetical is correct? That the trial court should have said, I'm sorry, we don't have enough time to take all the evidence, so I'm going to enter an order granting the motion for a pickup order. I guess, you know what? Relinquish the child.
No, I think the court should have
That's what I'm
said,
saying, right?
the
That's
court
what
should,
happen.
if the court is running out of time and needs more information,
Yes.
then it should say, we're running out of time, you need to show me by facts why the mother is unfit. That's what the court should have done.
Or, if they don't, in the time allotted, you have to grant the motion for pickup order, right?
No,
Is that what
it
you're saying?
depends on the facts of the case. In this case, there is nothing
The
to
trial
show
court
that.
can never continue a hearing on a motion for pickup order filed by a biological parent. Is that what you're saying? That's-
On these facts, the answer is yes. There could be.
So what, okay, so on these facts, what about this is a procedural issue, whether to continue a hearing. So what about these particular facts and the hearing that day suggest to you, that it was, the only answer was to not continue the hearing, but to issue the pickup order? Tell us how to write that opinion. What about, what you said is these specific circumstances? What about this particular hearing suggests that this court did not have the authority to continue the hearing?
There are two things. One,
Unless it's a categorical rule that a trial court can never continue a hearing.
I'm not saying that. And I'm not saying that if there was an affidavit or any kind of proof that in fact there was, my client was an unfit mother, then the thing can be continued.
Should we reverse this to finish up the hearing and find out what the facts in the record would support that?
Well, I think, Your Honor, is you're saying that my client, the mother, does not have the right to exercise her constitutional provisions, even though there's no evidence to indicate that she is an unfit mother. So the state has the right to interfere.
finished.
Pardon me?
The gathering of the evidence has not been completed.
But it should be pled. It's not even pled. There is nothing in here that indicates that the mother actions by clear and convincing
What about
evidence.
abandonment? What about neglect?
Neglect.
I'm not saying it was proven, but why wasn't it sufficient to place before the court the issue of whether there had been abandonment or neglect?
Well, first of all,
Excuse me, the verified petition says that the grandparents have been present with and cared for the minor child for all of the child's surgeries while the mother has failed to be present.
That-
If the trial judge accepts that fact as true, because it's in a verified pleading, along with the other recitations, including that she lives out of her car and isn't employed, and she's incapable of providing a safe, secure, and stable home. And that when she picks up the child, when she's visited, she smells of cigarette smoke and marijuana around a 10-month-old medically compromised child. We have to treat those as facts, because they're in a verified petition, they haven't been controverted in this record. How does that not add up to enough for the trial judge to hold an evidentiary hearing and want to get all the facts which she clearly did not, before making a determination?
if I may, the fact that my client was not living in the car is not a fact that has to be accepted. As a
Why
matter,
not?
it's my understanding, that may be wrong, but it's my understanding that when the court reviews an emergency petition, the court is only to review and to accept those statements that are factual. In this particular case, there is nothing. My client did not live with them. That's obvious. So how does she know? That is an opinion. That is a guess. That is,
You went to a hearing where she heard testimony from the mother.
Yes.
The trial judge heard the mother's testimony. And we don't have anything in this record that controverts the verified allegations. We're not the trial court. We're reviewing what is in this record after.
that is correct, Your Honor.
I understand. The trial judge did what she did, that you've asked us to review, which I have serious questions about our capacity to do, given the posture of the case. But to say that there isn't any factual allegation that the trial judge could have relied on for this ruling is not entirely correct, given what's in this petition.
All right. If let's say she's living with her mother. Oh, okay. Do I answer?
Go ahead.
The fact that first of all, they say she's unstable. I don't know what that means, and there's nothing that connects the unstableness, if there is any, and assuming there is, with her behavior with the child. She lives in her car. All right, let's assume that's true. The fact remains is there's nothing to connect that with clear and convincing evidence that the staying in the car makes her an unfit mother. Maybe that's why the grandparents had the child for a period of time. Maybe it was work. There are so many reasonable explanations for all of this stuff that you can't draw an inference that, in fact, what it is clear and convincing evidence that the mother is unfit with the child. The fact that she doesn't attend the surgeries. Well, you can't raise this assumption that there's an abandonment because you don't know why she didn't do it. There's nothing in here that indicates that. There's nothing. If they had a doctor who came in and said that the actions of the mother are placing the child in danger, that would be sufficient. But they put the mother and the son on, or the father of the child on, and didn't even bring the first witness, should have been the doctor, because you've got to connect the two. You can't just disregard and say, I'll tell you what, you keep the child, okay, even though there's no real evidence here, you keep the child and you lose your constitutional rights because, because the, let me think, I'm sorry. You lose your constitutional rights because that's the way it was, the status quo. That is not the law. Matter of fact, there is cases cited in my brief where the parent took care of the child, had a bonded relationship with the child, but when the parent came in, grandparent, then the parent came in, that was not enough, because you have to have clear and convincing evidence that there was that my client is unfit. And that is the burden. No matter, I mean, the court, I'm sorry.
Burn the clock, 2 minutes for your rebuttal.
May it please the court. Angela Leiter on behalf of the appellees, Nathaniel and Sabrina Johnson. First off, I don't think this court has jurisdiction to be addressing the issues raised here. The judicial labor of the underlying court was not completed. It's clear on the face of the order. And the hearing was not concluded in any way, shape, or form.
Your opponent, I mean, cut to the chase, your opponent's telling us, but here we are, and the child is now residing with its grandparents to the exclusion of the mom's ability to parent it. So, and so, assume that we do have jurisdiction for purposes of this discussion, this part of it. The trial judge tells us she didn't have a chance to review all the facts, and she did hear some, and we talked about that, but is that enough to meet the standard that your client is articulating applies here for purposes of keeping this child away from its mother?
Well, let's start with, it's been a long-standing tradition in Florida law across multiple jurisdictions that we maintain the status quo with children when there is litigation pending, because it is, and no, we are not on necessarily a best interest standard because this is not a traditional family law case. I would still assert the court has to consider, while the litigation is pending, the status quo and what is the most stable and best interest environment for the child. When this case was started, when the emergency petition was filed, the child was with the grandparents. I believe that's indisputed at this point. And so a child with some very severe medical issues, and unfortunately, without a transcript, you don't have the record to tell you how bad the medical issues are, but they're pretty extreme and require lots of special care. And so what's important, especially to maintain stability and keeping this child medically safe during the pendency of the litigation, it was in the child's best interest to keep him with his grandparents.
And your position is when they got here, the child was with the grandparents who, in their affidavit, at least in broad strokes, suggest that they were caring for and maintaining and dealing with the various medical issues without a lot of help from the mom.
Correct.
And so your position then is that's the status quo, we're not done yet, and let's go back and have a final hearing.
Right, and I would even assert more so that even in their brief, mother concedes where the child was, but not only does she kind of concede where the child was, it's in regard to the response about the child has come home from the hospital with the grandparents. And they concede by saying, well, that wouldn't have happened without the agreement of parents. So effectively, the child could have never gone to the grandparents' house without mom agreeing initially for the child to go to the grandparents, for the grandparents to take the child to the medical appointments. And that's where I think the important thing is, what we have to look at is where the child was when this case started, what's in the child's best interest, and the court ultimately makes the decision once the judicial labor is completed, once this hearing is even completed, because that is such a fundamental issue. It's clear as day that The judicial labor was not completed.
So
They,
do you think that we should dismiss this case for lack of jurisdiction? Is that your argument?
I believe so, though I believe there's other bases, I think for cleanness and to not encourage litigation, basically, if you don't like how a hearing's going, go appeal. Because that is what would be the public policy if the court were to say, oh, okay, you didn't like what the court did, they're not done with what they're doing, but you think it's only gonna go worse from there, well, let's go ahead and go talk to the second DCA and tell them how the trial court,
So basically cut them off.
Cut them off from-
Cut them off at the pass if we agree with the arguments that are made on this, let's say, unfinished record.
correct, because and I don't think it's just simply the public policy of not encouraging interim appeals, which, because I would assert it's not even really a non-final order appeal. Under the traditional rule, you would seek a non-final order review, because it's really an interim order. It's not an order that was concluded. Now, this gets to, they assert that because it is a constitutional issue, this court doesn't need a transcript. But then they continue to argue factual things that this court can't determine what was presented or not presented because there is no transcript that actually puts forth what evidence was or wasn't presented. Even continuing to talk about, well, if there was just an affidavit of a medical expert, but we don't know what was presented. And even from the record, we don't even know if any documentary evidence was admitted or not, because the court doesn't generally admit into the record the documentary evidence until we conclude a hearing. So what facts
We
are
don't have a record of proper, isn't a transcript.
right? Correct. And so we have no ability to determine what was presented. And, you know, this is something that maybe Mr. Bowen has an advantage over myself in this because he was trial counsel. But
what we do know is that the trial judge heard at least some testimony, and certainly was presumed to have reviewed the allegations in the verified petition. So we have to give the trial judge credit for having reviewed that much evidence on this, as you call it, interim order, right?
correct. And I would assert, based on the face of the allegations, if true, I think the court would have been in the position where they would have been required to determine that it was that there had been, at a minimum, neglect by the mother, even if the court didn't get all the way to abandonment,
And
just
did the court make that determination sufficient for this order based on the verified allegations and the testimony of the witnesses she identified who testified?
well, I would concede to an extent that the trial court effectively said, we're not done. So I'm not going to actually make the ultimate rulings, especially because where we stand with that order, we don't even know if the petitioner is arrested. I mean, for purposes of the record, we don't know if petitioner is arrested. We don't know if respondent had begun presenting her case or not. But I would say that based on the status quo and where the child had been, and going slightly out of this record, but it's a related case, the record in the paternity case also doesn't seem to show that there's ever been any order that moves the child from the home that the child was in with the grandparent. So I think that's an important thing to consider too, because it's not just one court, it's two courts have maintained the status quo and kept the child where the child was. And I think that's a very important consideration, because it's not that we're looking at a situation where we get to the constitutional level, because at this point, the court has made no determination to prevent mother from raising her child and exercising her constitutional rights to raise her child, because nobody's gotten that far. No, it wasn't concluded.
There are provisions, if I'm not mistaken, for the mother to continue visitation, right?
Correct. There are, and the mother has had free access,
Your
obviously,
Honor.
going.
I'm going to object to that. That's not in the record. I'm sorry. I don't mean to do that. I hate to do that.
She's doing
But yes, there were provisions maintained that would allow, there just was not a set schedule or anything like that put forth, but there was no prohibition that said mother is to have no contact with this child. So I think the court can look at what is the absence of what is in the record. It's not that there's a no contact order entered. There's not any sort of interim mother's rights are suspended or anything of that nature. It just simply left the child where the child was. Now, there's also some other arguments that are raised by mother's petition beyond the constitutional argument that are a little bit confusing, because it appears from the face of the petition, the face of the initial brief, that mother is seeking to have this case brought into dependency court, which doesn't seem like the scenario that someone is objecting to the state interfering with her constitutional rights to raise the children would want to seek. But regardless, the circuit court is a court of competent jurisdiction. The Florida Constitution does not lay out specific divisions of the circuit court. And in fact, different counties have different divisions in how they structure them. So I believe that argument.
Well, all of the pending motions were not brought in Chapter 39 either, right? The court has to resolve the motions that were brought.
Correct.
Petitions.
Correct. There was no private dependency action filed. There was no other form of relief sought under Chapter 39 or any other section. This was simply a petition for we'll call it temporary custody with an extended family member. So we're not even getting into any.
The mother's pickup order is still pending? Yeah, so those are all, then none of those are under Chapter 39.
Correct. Nothing was filed under Chapter 39, and in fact, nothing was filed really in any case that would be an ultimate resolution of mother's permanent rights. Everything is temporary, because that's how this type of petition would function, because the goal is at some point, and the public policy goal is that parents do get to raise their children. So talking about constitutional rights and the infringement, ultimately, nobody has done anything to infringe mother's rights, but more so, mother has her rights. They're still in full effect at this point in time. So based on where the standing of this case is, it's really, as much as I'm going to argue for the standard review, it ultimately comes down to the factual issues. And ultimately, it's a factual dispute, and it really should be looked at on abuse of discretion if the court does not choose to just dismiss the appeal wholly. But it comes down to the factual issues related to the issues raised by mother's brief, and that's without the hearing being concluded, this court has no way to determine the error by the trial court, because it just doesn't have the record, it doesn't have a complete hearing, and most importantly, the judicial labor is not complete, is not close to complete. And I think just importantly for the record, as to my argument before about the public policy of this, mother did not. The only thing filed by mother in the record is the notice of appearance of her counsel and this notice of appeal. There is not any affidavits. There's not a response to the emergency petition. There's not a response to the emergency motion. There's not any procedural motions directed at the petition. And there's not even a motion for rehearing asserting that, wait a minute, court, you didn't have the right to keep status quo, to even create a record of what factual issues were not presented. So unless the court doesn't have any additional questions, I'll concede the remainder of my time.
Very good, thank you. One, Councilman.
Well, she makes a statement that there was an agreement. That's true, there was an agreement for various reasons, but the fact is, my client went to pick up the child and they wouldn't give it to her. That was the end of the agreement. She says, well, nobody said that she can't do anything. Yes, they did. Where in this particular order is there anything that says that the mother has the right to raise its child and to do everything? Everything is related to the discretion of the grandparents. If the grandparents don't want the child to go with the mother, it won't. If the grandparents want supervised visitation, it's going to happen because there is no rights that we have. That's the whole point of this. It is not the status quo that counts. It is not, as argued, the best interests of the child. This statute is a deprivation of my client's constitutional right to raise her child because it is an interference. And the court, even though it could continue the hearing, must have, even in a temporary injunction, must have something to show that that the probability of success by the other side is there. There is nothing.
This is not a temporary injunction.
Well, I know, but it has to be treated as one because you're going by, the only reason that the child was with the mother is the grandparents refused to return the child. It wasn't an agreement.
But there's a pending motion for the grandparents to have custody, and there's a pending motion filed by the mother for a pickup order. How is the court supposed to resolve those before the hearing is completed?
Because there's got to be some evidence to show that there is a success, a likelihood of success, and there is no evidence. Even assuming everything that they say is correct, there is no evidence on that. I mean, you're delegating the right to my client to see her child with their third parties. You're delegating that right to the third party. Okay, I'm sorry.
That concludes